Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, a constitution bench of the Supreme Court ruled that selection process adopted by the Kerala High Court in 2017 for recruitment of district judges was illegal and violated the Kerala High Judicial Services Rules of 1961. The court found that the High Court had fixed a cut-off mark for the viva voce after it was conducted, which was not provided for in the rules or the notification issued in 2015. The court held that the decision was manifestly arbitrary and ultra-vires the rules. However, the Supreme Court refrained from unseating the candidates who were selected in 2017 as they had already been serving as judges for 6 years. The court noted that removing them would be harsh and would deprive the judiciary of experienced judges. The court clarified that the failure of the petitioner to get selected should not be seen as a reflection of their merit and should not hinder the future opportunities for selection. The Constitution Bench, comprising Chief Justice D.Y. Chandrachud and Justice Harishikesh Roy, Justice P.S. Narasimha, Justice Pankaj Mittal and Justice Manoj Mishra, heard the challenge filed by 11 petitioners who were candidates for the post of district judges. The petitioners argued that the selection process violated Rule 2C3 of the 1961 rules, which specified that the merit list would be based on the aggregate of written examination and viva voce without any provision for a cut-off mark in the viva voce. The court found that the High Court's decision to introduce a cut-off mark for the viva voce after its conduct was contrary to the rules and the scheme notified by the High Court. The court emphasized that the decision to prescribe a cut-off should have been made through an amendment to the rules rather than through an administrative order. The court concluded that the selection process followed by the High Court was arbitrary and ultra-vires to the rules. The Supreme Court Constitution Bench, comprising of Justice B.V. Nagaratna and Justice P.K. Mishra, delivered a significant ruling highlighting that an acquittal in a criminal case does not necessarily dictate the outcome of a concurrent civil suit. The court made the noteworthy observation during the hearing of a case involving a tragic collision caused by the appellant's son due to negligent driving. Importantly, a separate civil petition seeking compensation was still pending. The appellant in this case challenged the quashing of the final report filed in relation to an FIR. The FIR alleged that the appellant's son caused a fatal collision while driving negligently. The claimants filed petition seeking compensation and a separate claim petition by the appellant is pending. After further investigation, a final report was submitted stating that the incident was an unavoidable accident and not due to negligence. However, the Kerala High Court allowed a petition to quash the report implying negligence on part of the appellant's son. The court referred to previous judgments stating that the acquittal in a criminal case does not automatically lead to the same outcome in a civil suit. It emphasized that the standards of proof beyond reasonable doubt does not apply to compensation claims in road traffic accidents and that the claimants must establish their case based on the preponderance of probabilities. Next we have Delhi High Court. In a groundbreaking judgment, the Delhi High Court has emphasized the individuality and financial independence of women, stating that a wife is not merely an extension of her husband. The court's ruling came in response to a petition filed by a landlord seeking the eviction of a tenant from a shop in Sadar Bazaar to accommodate his married daughter's business aspirations. Justice Nazmi Waziri, presiding over the case, highlighted that a wife retains her distinct identity and has the right to pursue her dreams, aspirations, and financial independence. The court firmly rejected the notion that a wife is subservient to her husband or obligated to disclose all her financial details to him. In its judgment, the court declared that leading an ideal life is not the goal of a woman, nor should they be reduced to being solely as the wives of wealthy men. Justice Waziri stressed that the importance of self-worth gained through personal endeavors, entrepreneurship, and meaningful social work. The court asserted that aspirations of this nature should not be challenged in eviction proceedings based on the genuine requirement of the property. The court also recognized the psychological and emotional significance of a daughter's paternal or maternal home, regardless of her marital status or geographic location. It clarified that the married daughters are included among the dependents entitled to commercial or residential space provided by their parents. The need of the independent, in this case, the landlord's daughter, played a crucial role in determining the outcome. The judgment emphasized that a landlord's financial well-being or that of his wife's and dependent children is not the determining factor in assessing the bona fide requirement for eviction. Instead, the focus should be on whether the landlord has suitable alternative accommodation available or if he can provide the same to his dependents. The Delhi High Court has ruled that the competition regulator does not have jurisdiction to inquire into the business of licensing patents, as this is a matter of solely governed by the Patents Act. The court said that the Patents Act 1970 takes precedence over the Competition Act 2002 when it comes to the existence of a right by a patent holder under the Patents Act. The division bench noted that while the Competition Act deals with the issue of abuse of dominant position and antitrust practices generally, the Patents Act deals with them specifically in relation to patents. The case pertains to Competition Commission of India's inquiry against two firms, Ericsson's and Monsanto's challenge to CCI, which had alleged that the companies have failed to license their patents reasonably in the fields of telecommunication and agriculture, respectively, and have been involved in anti-competitive practices. Both companies contested CCI's jurisdiction to initiate such inquiry. In 2016, a single-judge bench of the High Court had dismissed Ericsson's objections, concluding that there were no legal impediments for the CCI to proceed under the competition law. A 2020 ruling against Monsanto's referenced in 2016 decision and arrived at a similar outcome, finally giving rise to the current proceedings. The CCI had argued that since the Competition Act deals with the abuse of dominant position and deriving its powers from the same, it can consider if a patent licensing agreement is unreasonable. Monsanto and Ericsson, on the other hand, submitted that the patents are dealt with specifically under the Patents Act, which already has provision to deal with anti-competitive agreements and abuse of dominant position, and so proceeding under the Competition Act cannot continue. Now let's have an overview of other high courts. In a recent ruling, the Kerala High Court declared a gift deed invalid under the Mohammedan law. The decision was based on the fact that the recipient or the donee was only permitted to enjoy a half a cent of the total 3 cents of the scheduled property. Additionally, the donor had not explicitly stated in the deed that possession of the remaining property was transferred to the donee. Justice P.G. Ajit Kumar, presiding over the case, noted that through examination of the gift deed did not reveal any evidence or indication that the donee has been given possession of the 2.5 cents of the property. On the contrary, the deed clearly stated that the donor would continue to enjoy the property. This lack of a provision regarding the transfer of property led the court to deduce the donor did not intend to immediately hand over the possession of the 2.5 cents of the property to the donee. The court emphasized that while the right to enjoy the property could coexist with the possession, the evidence did not support the appellant's claim of possession. The appellant's failure to provide additional evidence, such as oral testimony regarding possession, led to the court to conclude that the gift deed did not create a valid gift. The Himachal Pradesh High Court, in a case related to the Domestic Violence Act, has determined that practice of framing issues for the first time in judgment, burdening the parties with providing these undisclosed issues and subsequently deciding the case based on such issues, is procedure that deviate the well-established legal and procedural norms. Justice Jyotsna Reval Dua emphasized the importance of informing the parties about the specific issues or points they need to prove before directing them to present evidence. In the case at hand, Justice Dua, presiding over the matter, highlighted that establishing a formal marital relationship was not a prerequisite in proceeding under the Domestic Violence Act. The court emphasized that a relationship similar to marriage would be sufficient for the application to be considered valid. To support this position, the bench referred to Section 2A of the Act, which defines an aggravated person as any woman who is or has been in a domestic relationship with the respondent, including relationships that resemble marriage. The court also cited a previous Supreme Court judgment that expanded the definition of domestic relationship to include not only the marital relationships but also relationships of a similar nature. The Madras High Court has recently held that even if a marriage was not legal due to the existence of a first marriage, the second wife and the children born out of the second marriage will be entitled to maintenance under Section 125 of the Code of Criminal Procedure. The wife has filed an application claiming maintenance for herself and for her minor daughter under Section 125 CrPC. The husband had filed a counter statement disputing the very marriage and also the paternity of the daughter and consequently liability to pay maintenance. The wife had earlier filed a maintenance petition contending that he failed to maintain her and their son even though he was legally bound to maintain them. It was also submitted that he had demanded a sum of rupees 25 lakh as dowry, and when she could not meet the demand, he left her. The Orissa High Court has held that undressing a girl under the age of 12 years, sleeping over her and merely asking her to penetrate her private part with the male organ of the accused does not amount to rape. The bench noted that such an act would come under the purview of aggravated sexual assault, punishable under Section 10 of the Protection of Children from Sexual Offences Act 2012, and not rape as per the definition of Section 375 of the IPC, or penetrative sexual assault as per definition under Section 3 of the POCSO Act. The division bench further observed that even though the victim has not stated that the appellant undressed himself, in the court's view, the same would be an act of the appellant with sexual intent, which involved physical contact with the victim without penetration, and therefore it would come within the definition of sexual assault as defined under Section 7 of the POCSO Act. A division bench of Jharkhand High Court, while hearing a petition challenging the granting of promotion to the respondent to the post of executive engineer, observed that attaining eligibility and competition of minimum length of service are significant in case of promotion only when the government employees fall within the zone of consideration, and a government employee who has attained the qualification for promotion cannot claim a right to be promoted from the date he has attained such qualification. The court observed that there is a fundamental distinction between promotion and financial upgradation in service jurisprudence, and a government employee becomes entitled to financial upgradation on the date he completes the minimum length of service and attains eligibility. Moving on to miscellaneous news. The Allahabad High Court has dismissed a writ petition filed by Sri Krishna Janambhoomi Mukti Nirman Trust, requesting the court to direct the Mathura civil judge to decide the application for a scientific survey of the Sri Krishna Janambhoomi Shahi Masjid Idgah premises before deciding the objection raised by the suit by the opposing parties, the management committee of the mosque and the UP Sunni Central Waqf Board. A Mumbai court has acknowledged the significance of pets in a decent lifestyle while ruling on a petition made by a 55-year-old woman under the Domestic Violence Act. The magistrate court allowed the woman's request for maintenance from her estranged husband, considering her age, health issues, and 3 dependent dogs. The court rejected the husband's argument that the maintenance amount should not include provision for the woman's pets. It emphasized that pets are an integral part of a decent lifestyle and play a vital role in fulfilling the emotional deficit that arises from broken relationships. The court stated that this cannot be a ground to reduce the maintenance amount. In a significant development, the Supreme Court has done away with the necessity to seek its approval before transferring presiding officers of special courts hearing cases against Member of Parliament and Member of Legislative Assembly. A 3-judge bench of Chief Justice D.Y. Chandrachud, Justice P.S. Narasimha and Justice Manoj Mishra has modified the order dated 10th August 2021, whereby it made its pre-approval mandatory to ease the administrative work of the High Courts. In a win for the cricket fantasy app Dream 11, the Delhi High Court has ruled that Satta Dream 11 infringes its trademark in a malified attempt to rid the goodwill of the former. The single-judge bench of Justice Pratibha M. Singh, while granting a permanent injunction against the defendant Satta Dream 11, observed that it is completely arbitrary and the impugned domain name is nothing but a malified attempt to ride on the goodwill of the plaintiff's mark Dream 11. The said mark Dream 11 and Satta Dream 11 are similar, and there is a high chance of confusion between the two marks. This is especially true on the internet, where the difference between such domain names would not be easily distinguishable, the court observed. In the end, we have international news. In Canada, a judge has made a decision that says that the thumbs up emoji can be considered a valid form of signature. The judge believes that courts should adapt to how people communicate nowadays. Because of this, a farmer was told to pay a penalty of $61,442 for breaking an emoji thumbs up contract. Justice Keeney said that while this definition might not be official, it matches his understanding of the emoji. He stated that while a signature is a traditional technique of confirming someone's identification, newer ways such as emoji can also do so. Justice Keeney mentioned that a thumbs up emoji might not be the usual way to sign a document, but Still, it does two important things. It shows who signed it and it shows that the person accepts the contract. In this case, the signatory was identified by their cell phone numbers. In a significant victory against workplace harassment, a Royal Mail employee of Indian origin has been awarded over £2.3 million in compensation after her claims of bullying were substantiated by an employment tribunal. She filed her complaint nearly 8 years ago alleging intimidation and harassment from her superior when she raised concerns about a colleague receiving an illegitimate bonus. The tribunal concluded that her boss's treatment had a profoundly detrimental impact on her, describing it as catastrophic. Israel's parliament, the Knesset, has given initial approval to a bill that would restrict the oversight powers of the country's Supreme Court, advancing a contentious judicial overhaul. The vote, with Prime Minister Benjamin Netanyahu's far-right coalition prevailing over the opposition, has raised concern about the erosion of checks and balance within the government system. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.